Hi guys, good morning everyone, good afternoon. Sorry for being late. We had some technical glitch that we had to take care of. This is your host Sanjeet Bhatia back again with another video on PRATHAM Test Prep channel. So before we move ahead, I would like all of you to hit this like, share and subscribe button. That is something that you can definitely do right now. And we will move ahead for the session for the day, which is the legal affairs. There are some important legal affairs that have happened in the past 2 to 3 weeks. We'll be discussing those legal affairs today, right? So if you are not a part of our Telegram channel, do subscribe to our Telegram channel. The name of the channel is under CLAT@Pratham. So do subscribe it for all the free updates for last 2 years. You'll get all the material, video updates, and our session updates also for free, right? So you can definitely go and join our Telegram channel under the name of CLAT@Pratham. Now, if you are someone who's looking for personalized mentorship or counseling and you're not able to figure out that how to go about your examinations, how to start your preparation, what should be your preparation techniques, then definitely you can give us a call on 5 times 975 392, and we'll be happy to guide you through the whole process, right? So we are hand holding the students since the day that they start their preparation till the day that they get their call letters. As you know that we are the leading institution under the CLAT and the international education sector. So you can definitely give us a call and we will be ready to help you out. Okay, so definitely do give us a call today itself if you are looking for any mentorship or any counseling sessions in the future. Now, starting for the legal affairs for the day. So the first legal affair for the day was that the relief that is there under the category of bail, right? That the person cannot be denied bail because he will jump the bail, right? That is what is being said. And the surety that is being given with the bail is meant for the purpose of ensuring the presence of the accused. That's what the Delhi High Court has said. Now, what does that mean? Is that there was a woman who filed a case against her husband, right, under the section 498A and section 377 of the Indian Penal Code, which involves the cruelty on the part of the husband and his relatives, and also under the section 377, which has unnatural offenses. The person was granted bail. Now the court said that if the person cannot be said to be jumping the bail, right, they cannot be just said that they will jump the bail and not appear before the court, right? So they cannot be denied the bail on that grounds because there is a person who's called surety is present inside the whole case, right? And his whole very purpose is for preventing the person from vanishing, right? Because there is one more person who's acting as a surety in the case, so the person cannot escape. So basically, the relief here cannot be denied that the person will jump the bail, or that should not be the sole purpose of denying the bail, right? And the presence of the surety ensures that the accused doesn't vanishes anywhere else. Now, what did the court said? That the court said the grounds cannot be considered for denying bail to the accused as the surety is sought for very this purpose, that is to ensure the appearance of the accused, and the apprehension that the accused may jump the bail is not sufficient enough to decline the application, especially where the accused has clean antecedents. Now, this you can see that the court has been really, really clear here, right? That the relief has to be granted, and the only condition that the person will jump the bail cannot be considered as a valid point for not granting them bail, as there is surety also present in the case whose sole purpose is to make sure that the person doesn't escape, right? So that is the whole purpose of this case that we are discussing today from the Delhi High Court. Now, coming to the next legal affair, that there has to be separate forms that has to be created regarding the birth and the death of the person born to a single or unweaned mother via ART. Now, this is what is being said by the Kerala High Court, that there are a lot of people nowadays in the country and around the world who are giving birth to children without their fathers, right? So now the court said that the single mother who are conceiving through the assisted reproductive technology, right, is recognized having the field regarding father's details violates the right of privacy, liberty, and dignity, right? So every woman who gives a birth to a child, on the birth certificate name, there is a column for the father's details. Now the court is saying that such field regarding the father details to the person who has gone under the assisted reproductive technology is considered to violate the right of privacy, freedom, liberty, and dignity, right? Because if she doesn't have an husband and she has to fill up that detailed form of the father's column, right, which is not even needed for her. Now, this was happening when the Kerala government also stated that they need to have separate forms for the registration of the births and the death of the child born to a single or unweaved mother through the ART, that is the assisted reproductive technology, which does not have any fields regarding the name of the father and the details of the father. Now, as I quote what the court has said, is that under the circumstances, there is no rhyme or reason in requiring the petitioner to provide the name of the father in the form prescribed for registration of birth and death, right? Because a mother is giving birth to a child, she has taken the ART, then what is the need of having the details of the father? Now, requiring the petitioner to leave the column regarding the details of the father as blank, the issuance of the certificate of the birth or the certificate of death, leaving the space provided therein regarding the details of the father as blank, right? There's nothing written in that, necessarily affects the right of dignity of the mother as well as that of the child, right? So that is a very, very valid point taken up by the Kerala High Court. We can see that how the societal sensitization goes on taking place in the country and around the world, right? So this is how you grow as a society. Now you can see that they are questioning that not writing the name or not giving the details of the father can be considered under the right against the privacy, liberty, and the dignity of the woman. So that is a really, really great step that is being taken by the Kerala High Court regarding producing such forms which doesn't require the father details to such single moms and unweaved mothers who have gone through the ART also to get their children. So that is something that is commendable by the Kerala High Court. You can see that there is a change that is coming in the society through such decisions. Now, coming to the next part, that is the Uttarakhand High Court is to examine the prisoner's right to procreate. Now, that is a very, 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 very interesting thing to understand, that there was a bench of Justice R.S. Chauhan and Justice Alok Kumar Verma, and they were hearing a plea by the prisoner's wife, right, who was seeking a short-term bail because they wanted to start a family. Right now, the Uttarakhand High Court will examine the constitutional question regarding an incarcerated prisoner's right to procreate. Right, that if the person needs to start a family, as you know that there is a limited period of time for a woman also that she has that kind of fertility to go and give a birth to a child. So definitely, if the husband of that woman is inside the jail, then there has to be some significant setting that has to be done so that the prisoners also get their right to procreate and start a family even if they are in the jail, right? So that is something that is really, really important that you have to understand. And the Uttarakhand High Court has taken this one step ahead, and they are trying to question the incarcerated prisoners' right to procreate also. Right. So that is something which is really, really important for you guys to understand now, that these kinds of judgments bring a very, very different kind of change in the society and the future of justice system inside our country also. Now, this is what the Uttarakhand High Court is saying regarding the examination of the prisoner's right to procreate. Now, coming to the next news for the day. Now, throwing a chit at a woman, professing your love, right, goes against the modesty of that woman, right? And it is outraging the modesty of a woman. And the Bombay High Court said it is the most precious jewel of a woman, right? The modesty of a woman is the most precious jewel. So that's what the court has said. You can see that the court also quote these kinds of lines. Now, what was the court saying is that the accused deserves a chance to reform and modify his sentence to the period of 45 days incarceration along already undergone. Now the Nagpur bench, now this was the case under the Nagpur bench, that throwing a chit of paper which has professing his love for a woman or for a married woman outrages her modesty under section 354 and 509 of the Indian Penal Code. Right? So simple as that, that you can see that the modesty and the outrage for the modesty is being charged on the person by as if the action that was done by him for throwing the chit on the woman is not something that the court accepts, right? Or not something the society will accept also. So definitely it is against the modesty of a woman. That's what the court has considered, and the person will be punished under the same category. Now, coming to the next legal affair for the day is that the Supreme Court has directed the Election Commission of India to develop mobile app containing details of the criminal antecedents of the election candidates. Right. So now, if you know that the election candidates and a lot of people who fight in India tend to have a criminal background too. Now, the top court, which is the Supreme Court, told the political parties that they have completely flouted directions during the Bihar elections, that is the Communist Party of India and the Nihilist Party of that is the NCP. The Supreme Court issued additional directions to political parties to upload the details of the candidates with criminal backgrounds on their homepage of the respected party website to enable the voters to get the informations about the candidates. As you can see, that's a very, very straightforward asking that the court has done, right? That they are providing additional directions, right, to these political parties to at least inform the voters that the person who's standing under their constituency tends to have a criminal background. There is nothing wrong in that, right? So they have directed all these political parties to put on their websites regarding such criminal records of the candidates who are standing for such elections. Okay, so I hope this is also clear to everybody. Now, coming to the next news for the day. That is, the 127th constitutional amendment was introduced. Now, the central government here introduced the 127th constitutional amendment bill of 2021 on 9th August of 2021. Now, this bill, what is it doing? It is restoring the state powers to make their own OBC list. That is, OBC means other backward classes list, right? Now, who introduced the bill? The bill was introduced by the Union Minister of Social Justice and Empowerment, Virendra Kumar. Now, it was introduced in the Parliament to clarify some provisions of the 122nd Constitutional Amendment Bill, restoring the power of states to identify backward classes. That's what the court is doing here. So you have to understand that they have called on this 127th Constitutional Amendment, and it was also introduced by the Union Minister of Social Justice and Empowerment, Virendra Kumar. Right? So I hope everybody is clear with these newses for the day. The last news for the day is that the governor can pardon prisoners, right? That's what the Supreme Court has said on the 3rd August, that the governor of a state can pardon prisoners, including the death sentence cases, right? Now, when can the governor do it? When even before they have completed the minimum sentence of 14 years of prison sentence. Okay? This can be done before the 14-year time also. Now, the bench held that the governor's power to pardon overrides a provision given under section 433A of the Criminal Procedure Code, that is the CRPC. Now, what does 433A says? It says that mandates the sentence of the prisoners can be remitted only after 14 years of jail. Now, what did the bench observe in this case? That the section 433A of the Criminal Procedure Code cannot and does not affect the constitutional power of president or governor to grant pardon under articles 72 or 161 of the constitution. That's what the bench is saying. Such power is in exercise of the sovereignty and however the governor will have to act on the aid and advice of the state government. As you know that he cannot take the decision directly, he has to work on the aid and the advice of the state government in this particular case. The last thing that comes is that the court noted that the sovereign powers of the governor to pardon prisoners under Article 161 of the Indian Constitution is exercised by the state government and not the governor on his own in reality, right? So that is what is being said in this case also. So you can see that the governor has the power to pardon the prisoners, but has to seek the advice of the state government. And also the person has to complete a minimum of 14 years of prison sentence, and it is also covered under section 433A of the Criminal Procedure Code. So this is what was being held by the Supreme Court regarding the powers of the governors for pardoning the prisoners. Now, so that would be it for today, guys. Thanks for joining the live session. I guess it was a little late for you today, but do definitely comment on the comment box that what are the sections and the cases and what kind of preparation you are looking forward to, and I will definitely help you out on such videos. So do give us suggestion on what kind of videos you want further, and I will be considering the same. And I read all the comments, so do comment on the comment section that what kind of sections you require to revise or understand for your CLAT, AILET, MH-CET, SLAT, or any other law entrance exam. Okay, so that would be it today, guys. Thank you all. Best of luck. Stay safe. Use your masks and hand sanitizers. Maintain your social distancing. And if you are above 18, do get yourself vaccinated. Right? Thank you all. Bye-bye. Take care and hope to see you all on another video on Wednesday. Bye-bye, guys.